Lordship, with the leave of this honourable court, Lordship, I want to go a fresh memo in 2 petition, Lordship, where I am seeking just a clarification of the interim order, Lordship. One is moved by the degree college student, another was a private college student, Lordship. So there's a short issues involved and nothing to do with the issue.
They are the petitioners.
Yes, they are the petitioners.
Petitioners have moved some application for clarification
Yes,
of
yes.
order.
Not in the fresh petition we have filed, it petition. Only for the limited relief of clarification of the interim order, Lordship.
Where is your fresh petition?
The petitions are there, Lordship. FR numbers are there. It may be taken up end of the list, Lordship.
Petitions.
It may be taken up end of the list, Lordship. With a small issue is involved in this matter, Lordship. FR numbers are already generated, Lordship. I filed in the morning.
Call for the record. Call for the record. Have you,
sir, my lord, may I also make one submission? With my lord's permission.
Lordship, I have served a copy to the AG office. Even I have not made one petition. I have not made the state as a party because the university is the party. Is one petition. Another is the deputy director of the PU board is party. Both a copy. In spite of that, we have served to the AG office also. Only in respect of clarification. I'll give one more copy also.
With my lord's permission, may I also make one submission, my lord? With my lord's permission.
Let Advocate General is arguing the matter. Let him finish the arguments. Then we will hear the remaining petitioners.
Lordships, kindly, Lord 1-8, writ petition number 3942. It's not connected directly to these petitions, my lord. It's against the media. My lord, the students are going to the...
We have already asked them to...
Lord, the students are being deemed, humiliated, chased by the media, my lord, with cameras.
All right, we will hear you. We will hear you. We have called for the record of your case. That yesterday we have already told. That is shown in the constitution. That is shown in the constitution.
Please, my lord.
Yes, we will hear you.
At the end of...
My lord, I may also make one submission, my lord, with my lord's permission. Your lordship wanted to know, my lord, the number of my petition. This is FIR number 3923 yesterday. 3923. And my lords were also very pleased to direct its listing. Yes, my lord, 3923.
Wait for your turn.
Please, your lord. Great.
I must state before your lordship, we have taken, insofar as state is concerned, while reply, we have taken sufficient time. I will try and complete today itself, not as early as possible.
No, we will request everyone that we want to finish these cases in this week only. We don't want to spell it over to the next week. So whatever you have to argue, please confine it in, and to be very brief and make all possible endeavor to complete it within this week only.
Yes.
Please, your lordship.
Yesterday, I had brought to the notice of your lordships. If the petitioners have not placed no material whatsoever to substantiate the claim, but on earlier occasion, I wanted to cite Qureshi's judgment about how the Honorable Supreme Court felt. In the absence of any material, no such declaration can be given. That judgment I have placed, I'll just cite it before your lordships. In volume 1 itself. This was a case where slaughter of an animal was sought to. May I draw lordship's attention?
Give the compilation.
This volume 1 judgment number. First page. The judgment starts at page 53. And the relevant portion is at page 60, paragraph 13. In paragraph 13, I may draw lordship's attention to the last paragraph. What then we inquire starts by that sentence. What then we inquire are the materials placed before us to substantiate the claim that the sacrifice of a cow is enjoined or sanctioned by Islam. The materials before us are extremely meager. Now, this is how note their lordships. Meager. Lordships get it. Justice. Para 13, 1-3, page 60.
Yes.
Paragraph 13, 1-3. Last sentence, last paragraph in 13.
Yes.
Yes. What then we inquire are the material, that sentence comment is, what then we inquire are the materials placed before us to substantiate the claim that the sacrifice of a cow is enjoined or sanctioned by Islam. The materials before us are extremely meager, and it is surprising that on a matter of this description, the allegation in the petition should be vague. In the Bihar petition number so and so are set out in the following bold allegations. But then they extract the kind of averments which were made in that case, not something similar to this, and then kindly see how they interpret that material. The allegation in the other petitions are similar. These are met by an equally bold denial in paragraph 21 of the affidavit in opposition. No affidavit has been filed by any person specifically competent to expound the relevant tenets of Islam. No reference is made in the petition to any particular surah or the Holy Quran, which in terms requires the sacrifice of cow. All that was placed before us during the argument were Surah 22 verses 28 and 33 and Surah 18. What the Holy Book enjoins is that people should pray unto the Lord and make sacrifice. We have no affidavit before us by any Maulana explaining the implications of those verses or throwing any light on this problem. We, however, find it laid down in Hamilton's translation of Hidayah book, 43rd edition, at page 592, that it is the duty of every free Mussalman arrived at the age of maturity to offer a sacrifice on the Eid Qurban or festival of sacrifice, provided to be then possessed of nisab and be not a traveler. But I may not trouble lordships, my lords, to read the other portions of the paragraph, except not the last sentence there itself. Last paragraph, last sentence of that paragraph. We, however, lordships may kindly see, we, however, no material on the record before us which will enable us to say, in the face of the foregoing facts, that the sacrifice of cow on that day is an obligatory overtax for a Muslim to exhibit his religious belief and idea. Sorry, idea. In the premises, it is not possible for us to uphold the claim of the petitioners. I have cited this judgment only to drive home the point.
More relating to law of pleadings in great jurisdiction.
Yes.
Yes, all right.
On the second aspect of first, it being obligatory in nature, in any particular practice, the second test notes which the Honorable Supreme Court. But my submission before your lordships is, it is for the petitioner, for instance, the Holy Quran contains about 114 surahs. It's for the petitioners, it's not for me, but I am not the person competent to say anything. Neither the court in a manner, is not. So it was for the petitioners to demonstrate before your lordships, beyond their doubt, as to what is compulsorily requires to be followed. In the face of the second test which was laid down by the Honorable Supreme Court, that it must be obligatory in nature. Now, let's see. During the course of the hearing of this very petition, the court did not ask the petitioners what should be considered as obligatory, what should be considered as optional. I suppose, my lords, it is for them to have satisfied your lordships on this aspect. Now, it is for that reason that I read this last sentence in Qurayshis where they say, a reading of the Quran would show that sacrifice of animal on a particular day seems to be optional. Therefore, we do not hold it. That's all. Interpretation.
Where you have read?
But that is at the same paragraph which lordships are reading, last sentence. May I? We may, however, no material on the record before us which will enable us to say the face of the foregoing fact that the sacrifice of a cow on that day is an obligatory overt act for a Muslim to exhibit his religious belief and idea. But that has been, I can point out one sentence notes in the middle of that paragraph notes, which re-emphasizes this point. The very fact of an option, and there is one sentence note somewhere in the middle it commences.
The very fact of an option.
Yes, the very fact of an option seems to run counter to the notion of an obligatory duty. Therefore, my submission is not what is optional is not obligatory. What is not obligatory is not compulsory. What is not compulsory is not essential. Therefore, it doesn't fall within the realm of essential religious.
You mean to say, it touches yesterday's argument also.
Yeah.
Like our basic features doctrine of constitution.
Fundamental.
Basic features of the religion should be the focal point of.
Yes, most certainly. It should be the fundamental aspect of the matter. It is fundamental to the religion. It is very fundamental. Interpretation. But there is one, but in this context, what I wanted to submit before your lordship. Lordships must have noticed one argument which has been advanced by the petitioners. That is, they also say that they trace their right independently to Article 19(1)(a). That's linked to this present submission which I am making. It is their case that it is also our fundamental right under Article 19(1)(a) to wear the dress in exercise of a right of free expression. This is how they say.
Freedom of expression.
Freedom of expression. Not if that argument, according to me, is runs mutually destructive and contrary to the present proposition for this reason. If their argument were to be accepted, then, my lords, they would, persons who do not wish to wear that would have a fundamental right not to wear it as well, hijab. If they claim that they have a right to wear hijab, lords, under Article 19(1)(a), not under this, then certain members of the community, women, may not want to wish to exercise that right under 19(1)(a). Therefore, element of option is there. If it is optional, then, my lords, the very
that option is under Article
19(1)(a). No, that is their argument as well. No, their argument itself is that once you say your 19(1)(a), it is mutually destructive to the argument of Article 25. Now, I just want to bring to, in fact, large number of petitions which have been filed, some of them women organizations, etc. But they say 19(1)(a), women's dignity. I will meet that one. In fact, that is the case of the petition, respondent state as well. But what I want to emphasize is it's either 25 or 19(1)(a). It can't be both.
Or are they mutually exclusive?
Mutually destructive, I will say. The reason is, but exclusive, the reason is this one. 25 has an element of compulsion insofar as dress is concerned, assuming dress forms part of an essential ceremony. But I would say, once, let us say, lordships have to declare tomorrow, not only this one, any particular attire for a particular community or a religion as an essential practice. The consequences of that declaration is every member of the community is bound to accept that. But if not, they have the risk of being excommunicated from that community, being considered as somebody who is anti-religious, the consequences are very huge. Therefore, there is an element of compulsion. But 19(1)(a) is a very different right, a civil right. I mean, when I said civil right, fundamental right in a civic sense, wherein, Lords, you exercise what is known as a cultural. The concept of wearing a dress is a cultural right. You exercise it as a dress, as a freedom of speech, of expression. But then, once you say that, you also give the enabling right of not wearing it as
option.
Yeah, option. Therefore, if that argument is taken, then a member of Muslim community, women, would then have either an option to wear hijab or not to wear a hijab. Once you have that option, obviously, it is a 19(1)(a) right and not a 25 right. The corollary of that.
If suppose somebody wants to wear it,
Yes. Yes.
claims the right under 91(a),
Yes. But
Then-
we have taken a stand.
then if you are restraining it,
Yes.
will it not amount to
Yes,
violation of Article 91(a)?
according to us, under 19(1)(a), if somebody wants to wear a hijab, interestingly, in our country, at least, there is no prohibition for wearing hijab in our country. Lordships may kindly note, on 19 there is no prohibition. However, this 19(1)(a), Lordships are aware, is subject to 19(2), where the state can impose reasonable restrictions in the interest of morality, public order and health. Decency. Decency.
Honorable Chief Justice is saying, we do not travel to 25 at all.
Yes.
We confine our case to 19.
19. Yes.
To that, what is your answer?
Our answer is, my lords, that the right to wear a hijab as a 19 right, Article 19 right, can be restricted
Of course.
under 19(2). And our case is, insofar as the present case is concerned, Rule 11 of the Uniform Rules, Lords, place a reasonable restriction on wearing hijab as an institutional discipline.
Within the institution.
Within the institution. That is the reason I said in our country there is no prohibition of hijab. Everybody, wherever you want to go, you can wear hijab. But subject to I will put it across very subject to institutional discipline. This discipline may emanate from schools, hospitals, or military establishments, everywhere, every institution has an internal regulation and discipline. So that 19(1)(a) right, Lords, can be subjected to 19(2). It is open for them to say that 19(2) law which we have made is unconstitutional, which they have not done so, Lords, in the present case. Yes. That 19(2) law.
Generally,
Yes.
after R.C. Cooper case,
Yes.
before R.C. Cooper, our constitutional jurisprudence recognized these rights to be almost watertight compartments.
Correct.
Then that bank nationalization case,
Yes.
that came to be turned down,
Yes.
where they said they are not watertight compartments.
Yes.
They are companion rights, complementary to each other.
Each other. That is true. That is true.
And even in Maneka laid it emphatically. Cooper was on that part practically overruled in Maneka. The lordships are absolutely right. Maneka.
But my approach has been this. 19(1) they have invoked freedom of speech of expression. But that can be controlled by 19(2). Reasonable restriction on the exercise of that right on the grounds of public order, decency and morality. We have a law in the form of, Lordships are aware of that law also, Karnataka Educational Institutions Classification, Rule 11 rules. That law could certainly be called into question, saying that it is disproportionate, unreasonable, etc. Has not been called into question. The Karnataka Educational Institutions Classification, Regulation and Prescription of Curricula, Rules 1995, Rule 11. Now, it is this rule which imposes upon them a reasonable restriction of wearing a particular headgear. This is all this is, nothing more, nothing less. Of course, I thought I'll substantiate that by way of V.G. Rao and Chintaman Rao, both of them. I will cite it, but I just digressed a little bit on this question, only to substantiate for your lordships that the independent claim of a 19(1)(a) cannot go together with 25. Which one is it? No, we'll. But should I straight away state that V0 shall I? Lordships are aware, I'll just give the citation. Principles of.
You have argued this in that online Honorable Chief had asking.
Yes, I have argued, but I have argued unsuccessfully.
It is not that.
Many cases were lost by Palkiwala. If you read history, that will say.
No, it's okay. It's a very good set. Now, only one thing about this V0 I wanted to point out. How restriction should be construed. Very an authoritative judgment. I'll just read 2 sentences. May I draw Lordship's attention to paragraph 15. 151. This court had occasion, Lordship's case, in Dr. Khare's case. 1-5. This court had occasion in Dr. Khare's case to define the scope of judicial review under clause 5 of Article 19, where the phrase imposing reasonable restriction on the exercise of the right also occurs. And 4 out of the 5 judges participating in the decision expressed the view, the other judges leaving the question open, that both the substantive and the procedural aspect of the impugned restrictive law should be examined from the point of view of reasonableness. That is to say, the court should consider not only factors such as the duration and the extent of the restrictions, but also the circumstances under which and the manner in which their imposition has been authorized. It is important in this context to bear in mind that the test of reasonableness, wherever prescribed, should be applied to each individual statute impugned, and no abstract standards or general pattern or reasonableness can be laid down as applicable to all cases. The nature of the right alleged to have been infringed, the underlying purpose of the restrictions imposed, the extent and urgency of the evil sought to be remedied, thereby the disproportion of the imposition, the prevailing conditions at the time should all enter into the judicial verdict. In evaluating such elusive factors and forming their own conception of what is reasonable in all the circumstances of a given case, it is inevitable that a social philosophy and the scale of the value of the judges participating in the decision should play an important part, and the limit to their interference with legislative judgment in such cases can only be dictated by their sense of responsibility and self-restraint, and sobering the reflection that the Constitution is meant not only people for their way of thinking, but for all, and that the majority of the elected representatives of the people having authorizing the imposition of the restrictions consider them to be reasonable. But I don't think, Lords, I need to dwell much on the reasonableness of an uniform being prescribed to children, both at the school and the college. And interestingly, my lord, this uniform is restricted up to, my lord, 17 years, that is PUC 2, which is a very impregnable age, the minds of the children. And the preamble of the Act itself says that we want to give a secular outlook. We want people to wear uniform which would reflect uniformity. And the restriction also, my lord, I must point out, is not to wear the hijab inside the institution. There is no restriction.
Classroom.
It is only inside the classroom. And it is only during class hours. And it is uniformly made applicable to everyone. Nobody can wear anything else beyond their uniforms, irrespective of community, religion, etc. Therefore, I had 19 to, therefore, this is an independent argument. But coming back to this test, I have stated before, what is not obligatory, therefore cannot be considered as essential ceremony. Lordships have also seen the material. The third aspect, Lord, slightly something which I thought I must place before your Lordships and leave it. The discontinuation of a particular practice, does it have any change in the religion? something which does it so is a question which Lordships may kindly see. But
Five postulates. One of the postulates which I had said yesterday was one of them.
So the question is, Lords, in the present context, how does it reflect upon? I can immediately think of one example and I'll leave it because this is a matter, Lord, which concerns them. In France, Lords, I am told, there is a total prohibition of hijab in entire public life. But I don't think anybody can say that there is no Islamic religion in that country. That is how I want to put it. There could be countries, nations.
Why name one country? So many countries.
Yes, Turkey is there. France is something I have a ready-made material, the act itself with me. I will place it before your Lordship. But that's a test what I want to apply.
It all depends upon the constitutional policy of every government, every country.
Yes.
Nation to nation,
yes.
The extent of liberty, freedom, etc. that obtains on American soil.
Yes.
May not be obtaining on Indian soil.
There it is more liberal. Absolutely.
They all depend upon the constitutional setup. So many things will be.
No, I only wanted to point something else. Without hijab, can Islam, that is what France is an example. That is what just to test that principle. I'm not saying that is made applicable to our country. In our country, there is no prohibition itself. The question doesn't happen.
Islam is same for everyone, whether he is in France or in India.
There is no prohibition in our country. That is what I wanted to say. It's last year. Let's say Islam Farooqi, Dr. Ismail Farooqi, that Babri Masjid. There also this same one paragraph I just read. They interpreted Quran, volume 1.
That excommunication case.
No, this is
that Ayodhya.
Ayodhya. Where acquisition of that space took place. The contention was acquisition of a mosque, which is fundamental to the religion, runs counter to Article 25.
That whether the namaz is to be...
Yes. But what their lordships held is, there is a fundamental principle to offer namaz, not necessarily in a particular place. That's how their lordships. 94 must have been in rising from Uttar Pradesh, lords must have had some knowledge. So volume 1. Volume 1, this is page 225.
$25.
225. 220. Which paragraph?
First one.
No, first one. Ismail, Dr. Ismail Farooqi, volume 1. All the 276. May I draw Lordship's attention to paragraph 77 in this, which is at page 281. At paragraph 77 is the argument. The answer is at paragraph 82. Para 77. It may be noticed.
282. 77.
77. It may be noticed that Article 25 does not contain any reference to property unlike Article 26 of the Constitution. The right to practice, profess and propagate religion guaranteed under Article 25 of the Constitution does not necessarily include the right to acquire or own or possess property. Similarly, this right does not extend to the right of worship at any and every place of worship, so that any hindrance to worship at a particular place per se may infringe the religious freedom guaranteed under Article 25 and 26 of the Constitution. The protection under Article 25 and 26 of the Constitution is to a religious practice which forms an essential and integral part of religion. A practice may be religious practice, but not an essential and integral part of the practice of the religion. Kindly see paragraph 82, the next page. The correct position may be summarized thus. Under the Mohammedan law applicable in India, title to a mosque can be lost by adverse possession. If that is the position in law, there can be no reason to hold that a mosque has a unique or special status higher than that of places of worship of other religions in secular India, to make it immune from acquisition by exercise of the sovereign or prerogative power of the state. A mosque is not an essential part of the practice of the religion of Islam, and namaz by Muslims can be offered anywhere, even in open. Accordingly, its acquisition is not prohibited by the provisions in the Constitution of India. Irrespective of the status of mosque in an Islamic country for the purpose of immunity from acquisition by the state in exercise of the sovereign power, its status and immunity from acquisition in the secular authors of India under the Constitution is the same and equal to that of the places of worship of the other religions, namely church, temple, etc. It is neither more or less than the places of the worship of other religion. Therefore, notes, they negatived this contention. You have to introduce. But may I draw Lordship's attention to paragraph 65, how this finding came to be recorded. Para 65. Para 65.
278, Chief.
A larger question raised at the hearing was that there is no power in the state A larger question raised at the hearing was that there is no power in the state to acquire any mosque, irrespective of its significance to practice of the religion of Islam. The argument is that a mosque, even if it is of no particular significance to the practice of religion of Islam, cannot be acquired because of the special status of mosque in Mohammedan law. This argument was not confined to a mosque of particular significance, without which right to practice the religion is not conceivable, because it may form an essential and integral part of the practice of Islam. That's how Lord said.
Yes.
Reason why I cited this was, what was not stated in the honorable judgment of the Supreme Court is certain surahs in the Quran which mentions about mosque as being a place to offer prayers. Now, in the face of such injunctions there, if the court has held that that does not form essential integral part. But I do not want to trouble Lordship's to, I do not want to read it. I'll just give the surah numbers, but Lordship will place the Quran there. Surah number 2, my lords. Surah number 2, verse 114. Surah number 2, verse 144.
144 or 114?
144, I'm sorry. 145. I'll place everything, but I'll leave it not later on. I do not want to trouble.
144
and 145. Yeah. 187. Surah, same surah, verse 187. Surah 17, verse 2 and verse 7.
70.
Surah 2, so Surah 17, verse 2.
17 or 70?
No, Surah 17, once. That's Surah number 22, verse number 39. But I am I must state before your lordships, with all the responsibility, we are no experts. What we have done is, and it is the most difficult part of this case, I must say, we have ventured into, because it's the holy text of Quran. I am not an expert, except we have been able to get the English translation of the Holy Book of Quran by Syed Yusuf Ali and Mom Pitchell. Two books. I'll leave it with the court. I will not venture to read. But one first book is
Mr. Learned Advocate General, Apex Court has referred to so many books.
Yeah, I am coming to that.
Which author they have said? That author
yes,
will
but
take.
this
That
book
becomes
now,
easy.
which I am referring to before your lordships, that is, lordships may kindly note first. I'll say where it has been referred. The Holy Quran, Abdullah Yusuf Ali, the lawyer from Pakistan, Lahore. He has been referred to by the Honorable Supreme Court in Shahira Banu's case by consent of all, including All India Muslim Law Board. Lordships may kindly note that itself. I'll just Shahira Banu's case, lordships see. Chief Justice Keher's judgment. But he records saying that we are referring to the Holy Quran as translated by Syed Yusuf Ali, consented by all parties. One of the parties includes All India Muslim Personal Law. May I draw Lordship's attention to? Lordships may note it, so that I'll just read it and.
You tell the paragraph.
Yes, para 124 of Shahira Banu, 124, Chief Justice Keher's judgment. During the course of hearing, references to Quran were made from the Holy Quran, text translation and commentary by Abdullah Yusuf Ali. The learned counsel representing the rival parties, or the rival parties included all of them, commended that the text and translation in this book, being the most reliable, could safely be relied upon. The text and the inferences are therefore drawn from the above publication. So therefore, we have not ventured, and we have great reverence, respect, and prayers whenever we have to refer to these holy books. Except for referring to this translation, but we have not done. Those translation itself. The second book we have referred to is Holy Quran English translation by Marmaduke Picthall. Picthall. Picktall. He is an Englishman. But this book has been referred to. This book was referred to by His Lordship Justice Chandrachud Senior, Yashwant Chandrachud, in Shah Banu case. So both books seems to have been relied by the Honorable Supreme Court. The translated version we have placed before your lordships with the relevant portions. It would take a lot of time if I have to dispute. I will restrict myself in marking the relevant portion for your lordships perusal. As against which the petitioners have placed before your lordships a version from Quran.com, which we found out. It's okay. Which we found, I do not want to, and we are not disputing, but we found out to be a website created by few volunteers. It doesn't seem to have been authorized. But the translation, except for one or two words, seems to be more or less the same. So there's not much of dispute insofar as these verses are concerned. Sayyid Yusuf Ali's book, apart from the translation, also contains commentary at the bottom of those verses. But I would place that also for your lordship's kind consideration to draw inferences from the same. These books are 3 in number, so we can place it right now. We'll give it, but keep it. Yusuf Ali and Victor. It is not for us to elaborate. I leave it to lordship this one, how it should be construed. So Honorable Supreme Court, in each of the judgments have actually interpreted all of them. No, we'll just leave it. I don't want to go through it. It will take a lot of time. Because of the time constraint, I just want to leave lots of time.
We'll read.
Yes. Unless you want me to explain what, then I will. Whatever lordships you will not, yes.
What do you want to show from this?
Yes, we want to, I want to show. In Yusuf Ali, for instance, the reliance placed by the petitioners are on 2 surahs. Surah number 24.
This side we have to read from left to right.
No, this is on the as a normal book insofar as Yusuf Ali is concerned. Surah number 20.
Page number?
Yes, I'll just one. I'm just giving the page numbers.
Page 24. Verse 144. What verses? Yes.
But this is page number 904. No, 900.
Which verse?
Surah 24, verse 31. This is relied upon by the petitioners.
24.
Page 904, Surah 24, verse 31. Not as relied by the petitioners. Lords, get it. Page 904.
900?
904. But in that surah, of course, surah is there, verse is there. Verse is there. And it starts from and say to the believing woman. It starts by they should lower their gaze and guard. That's how it starts. Their modesty. They should not display their beauty and ornaments except what must ordinarily appear thereof. They should draw their veils for and not display their beauty except to their husbands, their fathers, their husband's father, their sons, their husband's sons, their brothers or their brothers. Now, the commentary by Yusuf Ali is at 2984 and 2985. Footnote. Next one. Yeah. Next one. Second one was next step also.
Is not. Hijab as such is not mentioned.
Yeah, that is what I want. I just want to
pattern it gives. Women should be.
It does not seem to be that.
How they should be.
Subject to what they would say. But then 3359 has been relied on.
Page number?
Page 1126. 1126.
Surah 33.
1126. Second one which has been relied on.
Surah?
59. 59.
29.
59. 59.
59.
Page 1126.
1126 is Surah 33.
Yes, no. 3359. Sorry.
Verse 59.
Verse 59. They have relied on this, subject to correction. And the commentary is down. Some footnote. There.
3764
3764.
in the commentary.
Note.
3764. Yes, 3764, 3765, 3766. 3. Lordships.
This side the number is given 376. Jilbab, Jura, Jilabib.
Yes, I saw. I've seen.
That talks about outer garment,
Yes, yes.
a long gown.
Yes,
Other than hijab.
yes, yes.
Now,
I
now,
know.
now it is not only headdress.
No, it is not the head. It is about that.
This verse 59
Yes,
of Surah 33 talks about a dress which is long gown.
yes, yes. This is what they have relied upon. But this is an area which I would little be more circumspect in making submissions. Something which is very holy to the community. I just wanted to place before your lordship whatever is there. Yes. Actually, it was for the petitioners to have come up before your lordships and establish. What is the implication of this? Except that something.
You mean to say that whatever the portion of the Quran which they have relied
Yes.
also does not talk
Speak
about
of this. This speak of this doesn't seem.
Hijab.
Yes. On a plain reading, unless that, on a plain reading.
But the Kerala High Court
I will come to
referred
that. No, what my lord's Justice Mustak's judgment, Kerala High Court is. But Arabic version of this speaks of Kumar, he says. Kumar, he says, is a cloth which is put over the head. There, Murad, the reference is to Hadith. Right? That is what seems to be. That is pre-Shahiraban. That is an interpretation. Yes, because I'll show before your lordship the distinction of Kerala judgment. This is what is placed on record. Doesn't seem to. Because the other test, my lord, is what happens. Not go into these aspects at all, whether it is an essential religious practice. Of course, it was delivered pre-Shahrabanu and pre-Shabrimala. The judgment was, the entire shift, according to me, takes place post-Shahrabanu and Shabrimala, particularly in this. Without Shahrabanu and Shabrimala, I think it would have been extremely difficult exercise for any court to ascertain these principles. This seems to have been settled. And Justice Mustak's judgment of Kerala High Court was delivered in that context. Of course, there are some inconsistencies in the judgment. Lastly, I will show that. But coming back to this principle, I rest insofar that issue is concerned to this much itself, that it doesn't demonstrate anything beyond the particular. The last argument.
Which they had banked upon?
They have one thing called Quran.com. There is no Quran.com is a website. This is what Mr. Kamath referred, that they subject to correction. What I do not know which.
In fact, very second day, Honorable Chief Justice asked what is meant by Quram.
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 Quram. Yes. But there is nothing in that.
But we'll reply, Lord. We have referred to Quran. We'll reply.
No,
It's Surah 24. We have referred because
which book? No, he's asking which book you refer. So,
Sayyid Abdul Ali Mujudi.
Mr. Kamath, I remember very well. No? Lordships did ask. That is not. Lordships were sitting single. Then he said it is Quran.com as website. I remember. Not recall subject to correction.
Yes, my lord. That's my learned AG is right, my lord. I relied upon Quran.com, which according to us has various translations of not the text.
No problem. There's no difficulty. There's no.
Lord, the word, my lord, interestingly, is Khimar. 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 which is telecast.
Yes. This is an area, my lords, I am little bit, personally, my lord, for me, I feel little.
It is learning for us also.
No, not that the courts have any, all the time. So that is the reason I showed earlier instances that they have gone ahead and interpreted. But in fact, not interestingly, one personal experience I can share. I had not appearing for the Awaqf board. Presently now it's known as Awaqf, that time it was board. One of the arguments which we had advanced was based on Ismail Faruqi itself, where we said the principle of Waqf is permanent dedication of a particular property to the Almighty, which is irrevocable once done, and it's only the usufructs of that which can be used for charitable, which is recognized by Islam as charitable. But on this principle, I had built up an argument saying that what is dedicated in Bangalore, a large number of tracts of land were donated by Tipu Sultan to a lot of mosques, etc. Those lands came to be acquired. The argument which was built was that once this dedication is permanent, you cannot acquire. So that was not accepted by the court. But this was based on the principle of Islam itself, of course. Therefore, it doesn't appear so on a plain reading.
The source which Mr. Kamath banked upon, tapped, whether those sources are judicially recognized as authoritative?
No, absolutely. I'll read that. What is the source? The credits, Lordship may kindly see, of this Quran.com. It is from the website of Quran.com. Who said Kudi?
Any high court in the country has treated it as authoritative source?
To my knowledge, no. But this whatever page we have taken out from the internet, they have taken out credits. They say this website was created by few volunteers and was made possible with the will of Allah and with the help of the open source Muslim community online. They have not, as a matter of fact, in their petitions, not relied upon any interpretation of this. Only given the English translation and then straight away rely upon the Kerala judgment. But the last leg of the submission is something totally not very linked to these, the three of them, on 19.1a, essential practice and the government order. In the last submission which I propose to make before your lordships is, assuming lordships are to accept every submission made by the petitioners, assuming every proposition is correct, but in the light of the law laid down by the Supreme Court, my lords, in Shabarimala in a different context, would it be possible today to accept the principle of hijab on the point of constitutional morality and not individual dignity? Well, I'll explain for your lordship why this submission is being made. But ultimately, if lordship see what is the claim of the petitioner sees, to wear a particular attire or dress, headgear or hijab or on whatever manner it is. If somebody is to come before your lordships and say, I want to wear it, that is 19.1a. But if somebody is coming before your lordships for a declaration that we want every woman of a particular faith to wear that, but would it not, my lords, violate the dignity of that person whom we are all sitting down and subjugating to, is my submission before. It is a compulsion of an attire which we want to impose on that particular person, which according to me, my lords, is impermissible in this day and age and as interpreted by the Honorable Supreme. A judicial declaration, my lords, to ask women to wear only a particular thing as a compulsion.
That is not their prayer. If suppose Hindu marriage, tying of Mangal Sutra is essential or not, if that question arises.
Yes.
And if we hold it is essential, yes, it does not mean all Hindus in the country should compulsorily wear the Mangal Sutra. It is left. We declare what is the legal position and leave it there.
But may I put it across in this manner? Lord, I do not want to take the example of Mangal Sutra, but I'll take the example of a dress itself again. But today, by way of a religious sanction, a judicial declaration is sought that we impose. It's not a question of choice. The element of choice goes away. That is the difficulty today. As soon as it becomes a religious sanction, the woman concerned, well, somebody may defy, that is different. But a woman concerned becomes obligated by way of a religious sanction to wear that particular dress. It becomes compulsory efforts. That is what my instructing counsel said. First, the first category. Yes.
You want to say that if suppose the court holds that it is an essential part of the religious practice.
True.
Then the women, Muslim women who do not wear it,
yes,
then it will amount to lowering down their dignity.
Certainly. That is how I. Yes. If they do not wear, they may be castigated as somebody who would not follow religion. And it is in the context of dress. And I don't think, Lords, but this, according to me, Lords, hits at the concept of liberty of that particular individual. The choice to wear what we want, the choice not to wear what we do not want. Every woman of every faith, according to me, Lords, has that choice. There cannot be a religious sanction by way of a judicial declaration. I'm only talking in the context of the court. If somebody wants to wear it, there is no difficulty. Absolutely no difficulty. Of course, institutional discipline, that is a different argument. But this is not just for college or school. This is for the entire world. Not kindly see in this regard. Why I have made this submission is, this is based on the interpretation by the Honorable Supreme Court in the context of Shabarimala, where women were, Lords, prevented from entering the temple. So this is in Shabarimala case, judgment of Justice Chandrachud.
Shabarimala, the review has been decided.
Yes, I wanted to come. Review was filed, review was dismissed, but now, Lords, about on 7 questions, matter is referred to a larger bench. Larger bench, or different questions are raised. But Lord, as of today, Lord, this is the law. Because Lordships are also aware of the position, merely because it is referred to a larger bench.
The question is also in that which has been referred, relates to Article 25.
Yes, Lordships are referring to the larger bench.
Which is pending.
Yes, no, that is correct. That is correct. No doubt.
So whether we are supposed to...
Yes, but on that aspect, the Supreme Court has laid down that mere fact that a judgment has been referred to a larger bench, the judgment which lays down the law continues to bind all the courts, including the Supreme Court.
So referent does not rob away.
So yes, there are some issues which would touch the question which is referred.
Lord, may I put it across in this way? As of today, my Lords, all the questions which we have, which has been argued before your Lordship, seems to have been settled down, both by Shara Bono and Shabarimala. It has been the endeavor. And whatever has been referred to a larger.
Please provide the reference order which has been made and the questions
Yes,
which have been referred?
I will.
Because that we will have to see.
Yes, most certainly. But may I draw?
A very short clarification. Review petitions in Shabarimala was only referred to be decided after the larger bench deciding the other 7 points in the larger issue. It is not dismissed. Review petition stands only deferred, not dismissed. Just as a clarification. For clarity on.
No, that is 2029 SCC 121, my Lordship's question. That reference order is 2029 SCC 121. Just one.
29. Therefore,
in SCC 1.
Between.
What is the legal authority?
Yes.
If a judgment is referred for consideration of
Yes.
a larger bench, whether other court should act upon
yes,
the ratio of those referred judgments or not, or we should await till
No,
they are decided.
No, Lordships may kindly see this judgment, but I have it.
Not decided.
I'm giving that attention to. That's MS Bhati versus National Insurance Company Limited. Citation is 2019 Part 12 Supreme Court Cases, page 248. MS Bhati versus National Insurance Company Limited, 2019 Part 12 SCC 248. Wherein the question was
Slowly.
I'm sorry. 2019 Part 12 Supreme Court Cases, page 248. Paragraph 5 and 10.
What has been held?
It has been held there that the law, that there was a judgment of Mukund Devangin, which was referred to a larger
Motor Vehicles
Act. The law which has been laid down by a 3-judge bench of this court in Mukund Devangin binds the court, notwithstanding reference, as a matter of judicial discipline, we are duty bound to follow that decision, which continues to hold the field. Then there is one. So therefore, if we do not follow that judgment today, it would amount to indiscipline. There are other judgments, but I'll also. But anticipating this, I had got this judgment. They are in my phone. There are 2 other judgments.
When you raised that issue, the Honorable Chief of
I had anticipated this note. I had collected judgments. Although there are 3 judgments, but all the 3, in fact, Lordships permit me to digress. Chief Justice Oak, I was to argue, a couple of cases, he used to always say this. Whenever we did not want his Lordships to take up, he used to say it is referred to a larger, and he said, no, it continues to bind us, we will follow it. This is in a lighter vein. He was very sure on that. But coming back to this issue of dignity, individual dignity, which I have just stated before your Lordship.
But in Learning the Law by Glanville Williams,
yes,
he gives 13 reasons as to when the presidential value of a decision is weakened. One of them is it's being considered
larger. But then, I was also great, as a matter of fact, I am told, BWSSP Rajappa, for instance, is referred to a larger bench 15 years back. When is it referred to larger? Referred to a larger bench about 10 to 12 years ago, I'm told, subject to correction. Many years have passed by. Of course, Honorable Supreme Court is yet to reconsider. Therefore, there cannot be a vacuum. Because it throws open important principles. Shabarimala throws open now what issue of dignity and liberty of a human being, woman, all that cannot be lying in languishing in vacuum. It requires to be followed and declared. That is my respectful submission. But Shabarimala, I have some knowledge as to why it has been referred to. But with some amount of responsibility, I can say that the questions there are slightly different.
Not what had been laid down.
Yes, that is correct.
That is all.
No, there is last, this, I'll finish, I'm finishing. This paragraph, I want to read last paragraph of Justice Chandrachud in Shabarimala to on this point of individual dignity in Shabarimala. Paragraph 221.
He is not touching constitutional morality.
Volume 5, I am told.
Yes.
Page 1649.
His view is suicidal. Chandrachud view. Going into Chandrachud view is suicidal. In Sabarimala. Because that is constitutional morality. That is suicidal. Even he touched upon untouchability in that.
Yes.
Right, sir. But before Lordships read this paragraph, kindly keep it in mind my submission. Women cannot be subjected to any a compulsion of a dress in the context of what has been submitted. Now, kindly see how his Lordships deal with this situation. Our conversation with the Constitution must be restructured to evolve.
Which paragraph?
221. Para 221. 1650. 221. Our conversations with the Constitution must be restructured to evolve both with the broadening of the concept of liberty and
content of liberty.
Is content of liberty and dignity and the role of the court as an enforcer of constitutional doctrine. The basic principle which must guide any analysis in this area is the dominance of the values of liberty, equality, and fraternity as instruments in achieving individual dignity. Once individual dignity assumes the character of a shining star in the constellation of fundamental rights in place of religion in public places, must be conditioned by India's unwavering commitment to a constitutional order based on human dignity. Practices which are destructive of liberty and those which makes some citizens less equal than others can simply be not countenanced. To treat women as children of lesser God is to blink at the Constitution itself. Among the fundamental duties of every citizen recognized by the Constitution is to renounce practices derogatory to the dignity of women. In speaking to the equality between individuals in matters of livelihood, health, and remuneration of work, the directive principles speak to the conscience of the Constitution. To allow practices derogatory to the dignity of a woman in matters of faith and worship would permit a conscious breach of the fundamental duties of every citizen. We cannot adopt an interpretation of the Constitution which has such an effect. Our inability to state that this is a matter of constitutional doctrine is liable to lead us to positions of pretense or worse, still hypocrisy. Both are willing allies to such critical issues under the carpet. If we are truly to emerge out of the grim shadows of a society which has subjugated groups of our citizens under the weight of discrimination for centuries, it is time that the Constitution is allowed to speak as it can only do in a forthright manner as a compact of governance for today and the future. Which is this? But then the competing rights, His Lordship has referred to, I will. So the central force of any interpretation is human dignity. Human dignity involves liberty. Liberty involves choice. The choice either to wear or not to wear. The entire claim of the petitioners is to make it compulsion, but that goes against the very ethos of the fundamentals of constitutional interpretation is what their Lordship says.
It finds this paragraph echoes the age-old saying of this country, Yatra narestu pujante, tatra ramante devata.
Yes.
Where women are respected, there the gods will dwell.
Yes.
That's how it is structured.
And I will repeat, no prohibition of hijab anywhere, but it cannot be compulsory. It should be left to the women concerned. In fact, not, sir. He wants me to read one paragraph of privacy motion. The very particular I wanted to end. I'll just read this. This Puttaswamy's judgment, Justice Chandrachud's observation, which goes along with this last paragraph.
Right to privacy.
Right to privacy. The Puttaswamy judgment. The entire thing we can't read. We can't read the entire thing. Just which is the This is in the context of competing rights. When you enter a school, you enter an institution, you may have a right, but there is also competing rights, how it should be. Paragraph 299.
Which volume?
Fourth, volume number 4. Huh? Volume 4.
You have read the Honorable Justice Chandrachud's version. What other members of the bench commented upon that? Did they agree or disagree?
No, but there is not much discussion on this concept. I must say. Conclusion is 4:1. Conclusion is 4:1. Separate reasoning given by more or less. Page 500. What can I talk? Sorry, paragraph 299. What? The last sentences, Lordships may kindly read. Last few sentences, commencing from the sentence. The notion that there must be a reasonable expectation of privacy ensures that while on the one hand, the individual has a protected zone of privacy, yet on the other, the exercise of the individual choices is subject to the rights of others to lead orderly lives. For instance, an individual who possesses a plot of land may decide to build upon it subject of zoning regulation. The building bylaws define the area upon which construction can be raised or the height of the boundary wall around the property. The right to privacy of the individual is conditioned by regulations designed to protect the interests of the community in planned spaces. Hence, while the individual is entitled to a zone of privacy, its extent is based not only on the subjective expectation of the individual, but as an objective principle which defines a reasonable expectation. Therefore, Lords, it is a right cannot be exercised in isolation when in public spaces, etc. Institutional discipline is paramount. But in my written note, Lordships permit, I will also give, there are certain other instances, I do not want to take time, where Lords, in military service, somebody had sought enforcement of an individual right. Like growing
that is Article 33 or what? There is
no, it was not even the I'm talking of
rights.
No, that is in the context. No, I know Article 33, but not in that context. This was the growing of a beard, which it was negatived on the ground that institutional discipline requires you not to exhibit individual choices. But arguments have been advanced also on Article 15 that somebody has been discriminated on the ground of religion. That is not correct. There is no discrimination. No other person of any other community has been asked to give preference over one other community. These are all bald allegations without any substance. We deny that, though it is not made public.
There can be an argument on Article 14.
Yes.
Not Article 15.
Yes. But not 15, that has not been. Then, my lords, just before closing down, two things I must bring to Lordship's notice. For petitioners like Mr. Mohan, who is sitting very patiently from yesterday, but private educational, he represents minority private educational institutions. I have found out we are not enforcing anything on them, so that they need not be aggrieved. These things are, the choice is left to each institution. They should not, is threatening to put TMA foundation upon us. But we have no way interfere. We have left it to their choice, so they must be rest assured. There is no question of this.
Oh, some direction has been issued by the state government.
No, we have not. We have left it to the choice.
It is mentioned schools, all schools is mentioned.
The colleges, PUC colleges, we have left PUC colleges. We have only said Padavi Purna Parva Shikshakar. But the question, Lordships may leave it.
If this is your stand,
yes,
then we can dispose of his petition recording
yes,
your stand.
Yes.
That you are not interfering.
No, I have obtained instructions also.
Mr. Mohan,
Because this instruction under the section 133 of the Education Act also.
No, he says that he has the instruction to say that the government is not in any manner interfering in the minority institutions.
That can be recorded. That
Private,
your only grievance is that
private unaided minority education.
No, aided also, because in Brahmati Education Act, law extended to aided also.
No, is there any minority institutions?
Yes,
which
minority
are
aided and unaided, both minority, talking minority, not beyond that. Because earlier, when Rights Education Act came, Rajasthan Society case, they said,
I do not
said unaided minority institution. Subsequently, the Constitutional Bench in Brahmati Trust case, where I appeared for a Muslim association, in that writ petition allowed, where in the
some institutions.
Petitioners are aided annually.
We'll take up your case.
Anyway, this is one submission I want to make. And for large number of petitioners who represent women organization, etc., they are before your lordships. On the question of women's right, yesterday they have filed some entry. No, I only want to make my submission.
We are not.
No, I'm just making this statement. This is exactly what I am also saying. The dignity of the woman must be kept in mind, not those submissions. Then if there is anything else, if my lords are to call upon, I will say. But I was just only one parting something which I want to mention before your lordship, that worse if lordships are to say, it says lower the gaze, etc. Lordships have to keep the dignity of the woman. Ultimately, in interpreting the whole thing, Lords, this morning when I was coming to the court, I heard a very beautiful Hindi song by Sahir Ludhianvi, where he says, Na muh chupa ke jiyo, na sar jhuka ke jiyo, agar gam ke daur aaye to muskura kar jiyo. Like nobody can put it better than that. We have all learned to lift their head high and live. That's what every woman should be trained, and we expect them to do so. But I am grateful that lordships have heard me at length. Anything note I will give, which will contain judgment of the European courts, which affirms Turkey.
We will request each of you, the petitioner councils as well as respondent council, to start preparing your written submissions, and so that without any further delay, you hand it over to the court. Now we will give 10 minutes time to the petitioners who have not put up their case till now.
Only on
There are four matters.
I just need about 10-15 minutes of reminder.
I have been made special one of the council, Mr. Venkatramani, senior counsel. He wanted to make submission on behalf of one of the respondents along with me.
Is he respondent?
He is appearing for me.
I to appear for respondents 12 and 13 in writ petition number 2146, your lordships.
My lords, I have a similar request. After, of course, Mr. Venkatramani goes, I'm, my lords, for a party respondent in 2146, for respondent 15 and 16.
First finish these matters. All right, we will first hear the respondent councils, then start with the fresh matters which are not yet handled.
I also hear for some other.
I'm indeed obliged, your lordship. I mean, let me try to be as brief as possible. Knowing and appreciating the fact that appearing for the teachers.
You are appearing for whom?
There are respondents for teachers.
In which
46.
WP 2146.
Same petition.
Page 10, the array of parties at page.
2146 for respondent number
12 and 13.
12 and 13.
At page in the array of parties, your lordship will find their.
Oh my God. Yes.
Let me be as brief as possible. There are only three broad propositions which I would like to urge before your lordships.
They are the teachers.
Yes. They are the teachers.
Shalini Nayak and Chaya Shetty.
That's right. They teach biology.
Yes.
Two very important subjects for modern knowledge, biology and
physics.
That's right.
Yes.
Where conflicts between faith and religion come into headlong collision sometime or the other. But I'm not getting into all that. I only want to have three broad propositions. One, appearing for the teachers, I appreciate and I understand that discipline and order is important both for the teacher and the taught. As a teacher, I would not like to see either a smoke screen or a screen which is rubbished with disturbing features in the classroom. I am not trying to say that religion A is higher, religion B is lower. No, there are no hierarchy of religions. Article 25 rightly recognizes that everybody has the equal right to practice and propagate their religion. The conduct of a teacher and a student must therefore be in the framework of the equality principle which informs the entire fabric of the constitutional scheme. But the teacher, I would love to have a free mind in the class because I must have a free mind. If there's no free mind for the teacher and the taught, there is no teacher. Therefore, my entire emphasis will be any measure on the part of the state or on the part of the school. Your Lordship, please.
Yes.
Any measure on the part of the state or on the part of the school to bring in a certain discipline and order, as long as, like the US Constitutional First Amendment, that no establishment, the state shall neither favor nor impose a burden. So as long as there is neutrality to enforce these two important dimensions of education. And then just make a note that different public spaces in a community, like a public playground or a theater or a transport facility, an airport, they all stand on different footing as regards public order, law and order, etc. School stands on a very higher footing. It is where people's minds come together with the only object of learning, knowing, and enriching one's mind and spirit. Therefore, the teacher, I place great emphasis on order and discipline, whichever way it is brought about. It is for the state to ensure that they follow a due process of law, that they ensure that they don't breach any rule of law, etc. But as long as these outer limits are not breached, and the state with a bona fide intention of ensuring order and discipline imposes a certain measure, I think the court will not hold it to subject to strict scrutiny. The strict scrutiny test in US constitutional law is for different purposes. Where an individual right is asserted, the court will be anxious to find out whether there is actually a right, an assertive right is valid, necessary for the enjoyment of that right, and whether the state has gone excessively in creating impairments on that right. Therefore, these broad principles, after all, ultimately your lordships know, governance is a very heavy subject. And those who govern know how to govern. Only when they commit a breach of governance on basic constitutional fundamentals, the court will interfere. The court will probably not teach how you govern. The court will only say your breaches of governance subject to constitutional law will be certainly scrutinized. That's a broad framework in which courts interfere. Therefore, I say great emphasis on order and discipline. You lordships look at any part of the world today, whether European countries, Justice Dixit put a very important question. The ethos of the country, the cultural background of the country, the long history of a nation. We have a long history. France may not have a long history of pluralism. So Europe today is passing through 100 years less of pluralism, merger, etc. And they can't even hold together. European Union is breaking for a number of reasons. So in European, maybe several countries have had several reasons as to why they will either impose a ban or not impose a ban. So to borrow a particular country's example mechanically and to engraft it on a constitutional discipline like India will be a little problematic. Therefore, I'll also try to point out, Lordship, I'll put my brief note that none of the judgments under Article 25, which have been cited at the bar, all those judgments are in the context of an assertion of a right to practice religion or certain aspects of it when a law relating to Hindu Religious Endowments Act or a law relating to regulation of place of worship are in conflict with an assertion of a right. None of those judgments have this dimension of a public order issue where the court strictly scrutinizes whether the state's got such a heavy burden. We are not in the realm of a criminal law. The state will not put a heavy burden as to establish what is public order. That public order must be narrowly seen or must be expansively seen. Therefore, none of those judgments assist the court in being able to look into this particular aspect of the case. I claim a right under Article 25, and that right is absolute. Because that right is absolute, then public order vanishes. That argument, I think, is excessively portrayed, and I don't think our constitutional scheme, particularly Article 25, facilitates that kind of an exposition. Now, let me come to the second aspect of it. I have my note where I thought I'll quickly read a few facets of my first submission. Let me quickly read from the Lordship's permit to do that. As long as the fundamental requirements of order and discipline in educational institutions is considered and treated as conducive and indispensable, mere deficiencies, if any, in the procedure adopted to bring about maintain order and discipline will not ipso facto lead to the nullification of the need for order and discipline and the decision taken in that regard. In matters of such importance and magnitude, since any small intrusions or scope for endless inquiries is granted, the likelihood of impairment of both order and discipline will become a matter of concern. Next, the above broad propositions have been stated, while they are self-evident, only to emphasize that the scope for inquiry in such matters will be narrowly tailored and expansively drawn. The answering respondents wish to submit that their concerns are purely connected to the importance of the above stated proposition as essential for their role as teachers. It is also understood that as long as order and discipline, which enables them to discharge their duties freely, fearlessly, and independently, and with no other thoughts or ideas impeding them, it is no part of the role of the teacher to embark into any other inquiry. It is submitted that rules, regulation, instructions, or any such forms or maintenance of order and discipline provide only the objective, the existence of the requirement of order and discipline. Such rules aid the mind of the teacher and student and also guide the entire educational institution. The teacher and the taught need to internalize the ideas behind these rules and shape their conduct. The teachers act as role models and mediums of expression such values. Now, let me go to the next proposition. Therefore, I think whichever way the public order has been perceived, as long as perceived properly, whichever way it is brought to execution, as long as there is no malafide or improper purposes, the court will not enter into any further inquiry. Now, let me go to the second proposition. The second proposition on Article 25. Let me quickly delineate what I find are the dimensions of Article 25(1). Under Article 25, all persons are entitled to freely profess, practice, and propagate religion on basis of equality. That's number one. Two, all persons are equally entitled to freedom of conscience. Then C, the discrimination of equality connotes, this dimension of equality connotes that the state will neither enter into debates with religion nor act in any manner conferring favors or imposing burden. That is the First Amendment to the US constitutional law. Next, regardless of any claims in respect of practice of religion, insofar as such claims impede or clash with public order, have consequences on morality and adversely impede dimensions of health, dimensions of public order, morality, and health, the state may have the duty or obligation to bring about regulation, restriction, or prohibition, as the case may be. Therefore, this proposition is the right to equality right to practice religion or propagate does not mean that either the state will enter into discussions on what constitutes religion, as long as whatever may constitute religion, as long as that constitution collides or there is a collision with public order, morality, and health, the state will come in. For the purpose of public order and morality and health to come in, the state need not necessarily inquire into what constitutes the essential practice and what is not essential. Whatever be your practice, the scope and extent of your practice, whatever be your assertion, the state will only say, your assertion insofar as there is a collision with public order, morality, and health, I will stop you. Therefore, Article 25 is very clear. Subject to public order, morality, and health, you have an equal right to propagate your religion and equality as far as conscience are concerned. The other debates, as I said, about the context of individual. In Article 25(2), when the state comes in for the purpose of regulating any economic, social, financial, or political activity or other secular activity connected to the religious practice, the state comes in under Article 25(2). That is where the regulatory power of the state comes in. So when the regulatory power comes in, the question as to whether you can regulate at all and what are you regulating? In that context of regulation and the competence to regulate and the extent of regulation, issues such as what is essential practice and what is not, what is integral and what is not, all those questions come in. But as far as 25(1) is concerned, the dimensions of Article 25(2) for the purpose of regulation, etc., does not enter into the domain of Article 25(1) at all. They stand in a different footing altogether. Otherwise, Article 25(1) could have begun with not subject to public order, morality, and health as the state may enact under a law. Then we get into a different dimension. So Article 25 does not even say the state need to enact a law under 25 for the purpose of bringing in public order. Your Lordship knows public order is the entry 1 in state list. Public order is the entry 1 in the state list, and it is essentially so because in the federal sector discipline, it is states who have to maintain public order. And as long ago said in 1955 in Rai Sahib Ramjavaya Kapoor, the whole extent of the executive power of the state under Article 162 is not only coextensive with the legislative power, but it enters into wide range of dimensions of governance. All those wide range of dimensions of governance, going back to 100 years, let us say, governance would have been a different task. Parliamentary system of government in England would have been a different issue altogether. The growth of administrative law in England focused on an unwritten constitution. But today, with the constitution, rule of law, democracy, pluralism, and globalization, and the merger of a wide range of global values in law, technology, science, etc., governance becomes a very difficult, complex subject. That's why I just want to read out one a very interesting passage. I'll share it with Lordship in a book on administrative law in US, talking about the expertise and science in bureaucratic life. The author makes very important, pertinent observation. Let me read it. To be sure, the attractive claim of bureaucracy is that it permits the mobilization of appropriate and specialized experts to whatever task is at hand. This suggests the image of an automobile assembly line or well-organized warehouse of parts. The organization provides just the right gizmo at just the right moment for every task within mission. But of course, the subtle problems of modern policy making are more akin to automobile design or composition of a symphony. Very beautifully put. The artistry is in the complete vision and in the integration of the subsidiary skills. No natural law assures us that a collection of skilled musicians will produce a beautiful music. And no natural law of management assures us that a collection of experts will produce worthy administration. So therefore, contemporary governance with all its challenges. So as long as broad principles of governance and adherence to rule of law is kept in mind by the government, the court will be very slow to interfere in matters like this. Therefore, Article 25 being so clear, all those case law being cited under Article 25(2) or dimensions of rationality, reform, whichever religion, the last submission about dignity and freedom of expression. I just want to digress for a few minutes. Now, there are different thoughts. I was just reading a book on expression of identity by Muslim women in India. 2 illustrations are given by this author. They go to Lucknow and then talk to 2 well-established women in the Islamic religion and how they have tried to navigate their problems with orthodoxy. I'll share all that with you. Why I wanted to bring this is, when you talk of, you are right under Article 19(1)(a), ordinarily we understand. I'm not going into those details. Ordinarily we understand it is self-expression. In the Association of Democratic Reforms case and the PUCL case, the voting Supreme Court said a form of expression. So expression can be art, painting, music, any form with the human mind or the human soul would like to aspire to express. And what are those expressions? Freedom, liberty, and to promote values better, which will better and advance, like Tagore talked in his verse 32 in Gitanjali, where there is no domestic walls will not be there, in the world of freedom, let my countryman away. All that great exhortation, that's why freedom of expression comes in. Freedom of expression does not go to the dark ages. We want to go ahead, not to go back. I'm not even belittling what is said in the Holy Quran. That I am nobody to say that. I think no one should do that at all. It is a holy book, and people want to practice that holy book, and then they must practice it. They must have all the freedom and enabled by the state to practice that. But when you enter into a public space, which is a qualified public space, I say therefore, unlike several public spaces, school is a qualified public space. It has its own dimensions. So to compare it to any other public space, a home or a mosque or a place of worship or a place of entertainment, it's completely misconceived. So every public space will have its own dimensions, unique features, and public order will therefore be as relevant to the particular public space will be looked into. That's how public order will have to be seen, not in a generic sense, not in an abstract sense. And you also know several judgments of the Supreme Court on public order, both in the context of the legislative competence and otherwise, I've said it has got an expansive meaning. The context will probably color the meaning. So therefore, the context here is a very special, unique public space called the school. Let us not, for the purpose of enabling the practice of religion, whatever be the dimension of that practice, let us not for any moment enter into diluting the vibrance and the importance and the insulation of the public space from intrusion by any extraneous elements. Whatever be the perspectives taken in the Turkish case, I'll presently place only a few paragraphs from the judgment. They're all governed again in the European context. European human rights, the European Convention or the Universal Declaration of Human Rights, or the International Covenant on Civil and Political Rights broadly talk about the right to practice religion, faith, and conscience, but they also talk about morality. There is no international human rights covenant which does not address itself to public order, morality, and health. Every institution, both at the international and the domestic level, are conscious of the need to ensure that governance is premised on these values, particularly because the assertion to practice religion. We all look at the War of Crusades in Europe, 300 years of bloody violence in Europe. And that's why the Holocaust of Germany's fall. All these experiences have informed, human rights drafters and later even the European Convention. In European level, that's very important to balance these considerations. But we are a different country. We are already as a nation. We as a nation, both culturally, historically, have been pluralistic in all its manifestations. But therefore, but having regard to the experiences outside the world, the constitution makers thought that we should not have all those experiences here. Therefore, they said public order, morality, and health may be the guidelines where the state, with all its responsibility, will ensure that without looking right or left, it looks ahead and says, look here, this will produce order, discipline, promote wide range of community living. Well, that's good for the community. That's what has happened in this case. When it was stated that public order is being excessively stated here. Several Supreme Court judgments and courts have taken to view even a breach of a little turbulence at a local area is also a public order question. Today, it is not merely Udupi. We find the entire nation is now brought into the solution. People in Tamil Nadu are agitating again. I find 3 days ago in Kota, there was an agitation, a public meeting. And internationally, the court is being, the proceedings are being watched, and how this dimension of this debate has a complete implication for democracy, rule of law, pluralism, so on and so forth. Therefore, it is not a very small proposition as sought to be made of. That's as far as Article 25 is concerned, because I want to be as brief as possible, though I would have loved to say many things in person. So the next small is about that importance placed by Mr. Kamat on the Constitutional Court of South Africa, the judgment. A small note, I've gone through the entire judgment. Just as none of the judgments under Article 25 in the Indian Constitution, which have been cited, have any bearing on the public order question, the South African constitutional judgment have no bearing on the public order question. There, very wisely, the Constitutional Court of South Africa plays a balance. It says, I look at your cultural dimension.
How it is relevant to level.
It is asked that question when that was cited here.
I read it very carefully. The court has played it very balanced view on that. The court, while trying to find out whether it is religious right or a cultural right, has not emphatically answered that it is a religious right. It goes on equating both religion and culture on the same footing, but the emphasis is on the cultural dimension of that right. And then the parade of horrible, in fact, is referable to Justice O'Connor's US Supreme Court judgment in an earlier judgment. So I asked myself a question. If suppose tomorrow, several other religious persons or persons belong to other religions persuade their own students and their wards to go and demonstrate in the school and assert your right, you can't call them parade of horribles. You can't reduce that kind of a level. If Islam practicing hijab is a faith, as good as in Holy Quran, practicing even wearing a tilak on your forehead can be as important for anybody else. So the parade of horrible is there for a different purpose. In our country, each faith has its own, domains and dimensions where you live peacefully, in community. I come from the Union Territory of Pondicherry. I've never known there while as a student. I studied in Loyola College in Madras and also studied in a convent school in Pondicherry. We have never known any clash between religions. In different parts of the country, for different reasons, as we find clashes for assertion of social, economic, and political rights today. There are different competing claims. Some authors write that what is happening behind these assertions is there is alienation. They feel insecure. Therefore, they express themselves in this way. So these reasons may be legitimate. We cannot go into those questions before the court. But as long as these reasons, the legitimacy of the reason does not mean the state is powerless to deal with these questions. Legitimacy of reasons will be a pointer for the state to find out whether what other remedial, social, economic, political measures would be deserving, would be important, and then embark on them. But that's a different issue altogether. Therefore, I find on the social media today, several people writing on the issues talk about the reasons behind it. Reasons may be absolutely legitimate, but the reasons will not probably come in the way of the state to say, I take a very important view on public order. So I come back to that issue. Therefore, I do not want to say that I will place several judgments before Lordship in my compilation. I've also collected some extra from some commentaries on right to religion in US, Europe, Germany, and England. I'll place all that, and it's too short a time for me to read out in extenso. But in sum and substance, I find that unless in the same constitutional or legal context, or unless in the same context where a framework of law is common and similar, and facts are similar, and reasoning is also based on similar facts, then one can understand, as long as that is not there, to borrow a judgment from a foreign jurisdiction and to apply it will be problematic. Your Lordship may know that Justice Scalia had a different view on foreign law being applied in US courts. We are not averse to foreign judgments. Today, a whole range of subjects in law is full of foreign citations and foreign law. We cannot close our eyes to all that. But the importance of bringing in a particular judgment from foreign jurisdiction in the absence of several comparables. In the absence of several comparables, there can be a misconceived application.
Yes.
I would like to conclude with that, and therefore, as a teacher, I do not want to go anything beyond that. Your Lordship give me permission to put in my written submissions within 2 or 3 days.
Yes,
I'm extremely
Thank you. Thank you. Yes, Mr. Sajjan.
My lords, actually, Mr. Naganand is waiting, my lords. Inter se seniority, my lords, he has a right. Therefore, I will yield, my lords. After Mr. Naganand, I will.
All right.
Mr. Sajjan Poya wants to argue, my lord. I don't want to come.
No, not at all, sir. Please.
We are here to decide this dispute.
Lord, there has been a exhilarating debate, and I can, my lord, fathom the extent of study, reflection that your lordships will not have to indulge in before coming to a conclusion in this case. Not for any other reason, Lord, but for the fact that such a myriad views or points of view have been placed before your lordships. But I want to be a little more mundane and would request your lordships to kindly take the writ petition 2146 in which I appear for respondents 5 to 7. They are not WP 2146 of 22. Respondent 5, Lord, is the government pre-university college for women, and 6 is the principal, and 7, Lord, is a lecturer in English.
Vice principal.
For 3 of them. The respondents 5 and 6, on their behalf, a statement of objections has been filed. I suppose, my lord, that would be placed for your lordship kind consideration.
Yes.
Now, my lord, can you ask me the petition, my lord? I would only draw your lordship's kind attention to the prayers in the petition. They are somewhat unusual, if I can use that expression mildly. Page 23. The first prayer, Lord, is a writ of mandamus to respondents 1 and 2, which is the state, to initiate inquiry against respondent 5 college and 6 for violating instructions in the guidelines at Annexure J. The second, my lord, is a mandamus to respondent 3 to conduct an inquiry against the college and its lecturers for hostile approach. Then a writ of co-parentum against respondents 15 and 16 as to how they are functioning as a CDC committee. And fourth prayer is declare that the status quo referred to in the letter of 25/1/22 is with consonance to the guidelines. So the entire frame of the writ petition is based on the guidelines and its enforceability. Whereas in the entire writ petition, my lord, we don't get any either specific plea or authority as to what is the factual position in this college. These petitioners, my lord, they have not said when they joined the college, were they wearing hijab, how many other students were wearing, nothing is stated. In paragraph 5, this is the bold pleading, para 5, at page 12. The petitioners are students of government PU college at Udupi and wearing their regular headscarf over the college uniform. Respondents 6, 7 and 13 insisted the petitioners to remove the headscarf by shaming them due to their conduct in invoking the religious identity. They don't say when they join the college. They don't say that when they joined the college, their parents signed an undertaking to say that we'll abide by the uniform rule. They don't say from how many days they have been doing. They don't say when all this happened. Nothing, my lord, is stated. And in paragraph 7, they say in the month of August 2020, respondents 6 and 7 rebuked the petitioners and tell them that their parents had signed the consent letter at the time of admission, accepting the terms and conditions. Then they were being scolded, etc., etc. This is the bald allegations on the basis of which, my lord, the matter has been raised by them in the writ petition.
So please show the adoption.
Paragraph 14, they refer to this College Development Committee. Now, my lord, in this context, could your lordships, my lord, please permit me to show our statement of objections. In the first few paragraphs, I have, my lord, referred to these prayers being misconceived. I will not read them once again, my lord. Paragraph 7, Lord. This is now a factual issue on which the court is now called upon to decide. Para 7. It is submitted. Has page 3, para 7. It is submitted that girl students of the petitioners were not in the habit of wearing hijab previously. Lord, if I can just pause. This is an entirely girls' college. No boys are admitted here. However,
please show the annexure, sir.
Yes. However, occasionally, some parents of the Muslim girls used to inquire whether the wearing of hijab is permitted during the college study hours. Further, the parents of Muslim girls requesting for wearing of hijab would request the principal and the teachers to ensure that their daughters are not involved in singing, dancing, music, and other extracurricular activities. Now, my lord, a different context is given now to the whole thing. I don't know if they mean that Muslim girls should not sing with their classmates. If national anthem is sung, they should not sing. Is it against Islam? If they are taught a devotional song on the country, Mother India, they should not sing. What is this that they are supposed to say here? No, none of these things are not anything to do with religion. There's a fine line of distinction between religion and culture. Now, I'll give an example, my lord. In the south of India, at the time of marriage, and particularly in some communities, not all communities, even in the south of India, my lord, I know that in the community coming from the South Canara district, Hindus, when they get married, they did not have the system of a Mangal Sutra. There was no tali that was being tied in South Canara. Now, my lord, what happened was that in rest of the Karnataka areas, Andhra Pradesh and Tamil Nadu, tali is an essential part of a wedding. People think when you are invited for a wedding, the minute the Mangalya Dharana is over, there'll be big commotion going on. Lot of drum beating will be there. Everybody will say, now I'm ready for lunch. Come on, let us go for lunch. Marriage is over. So this is a cultural thing. It has nothing to do with religion. Same thing, Lord, with wearing toe rings. Now in South India and some of the communities, toe ring is put onto the toe of the woman at the fag end of the wedding ceremony, and she is supposed to keep it on. And most of them, Lord, who would like to follow it, keep it on. That is not religion. The Saptapadi, Lord, which is an essential rite to be performed in the wedding, as per Vedic scriptures, Rigveda and Yajurveda, both of them prescribe it. And the mantras are different, slightly different mantra. The oath is different, Lord, in Rigveda and in Yajurveda. So the Saptapadi is considered to be an essential feature of a rite to be performed for the marriage to get completed and sanctified. That has to be done in front of the Agni, which is established there. Now, in many other Hindu communities, this is not there. There's no concept of Saptapadi, especially among Bunds. The many other weddings that are celebrated, it's not there. So, if one sect of a religion, they choose to follow a particular procedure or a practice out of local conditions, Now, my lord, I was giving the example of South Canara Bunts, my lord, coming from the Bunt community. Many of them have gone and settled, my lord, in Maharashtra, in Bangalore, and all the other parts of the world. So now, if you go to a Bunt wedding in Bombay, you will surely see that there is a Mangalya Dharana that takes place. Same thing in Bangalore also, because they have integrated to this culture that is here. Another aspect, my lord, among the Christian weddings, if your lordship should go to a Roman Catholic wedding, the girl and the boy, the girl does not wear any angavastram or any cloth above her shoulder. This is a typical cultural practice that is there among the Hindu weddings. All the Hindu weddings that we see, the bride is decorated, the bride wears nice clothes, wears something in her hair, and she never goes on to the wedding mandap without her shoulder being covered by one more vastra, a sari. Now, the same practice is there in Kerala, in Christian weddings. Whereas the practice is not there among Christian weddings in Goa. It's not there in the Russian Orthodox Church. Now, my lord, what I'm trying to say is this, that there is a distinction between an essential religious practice and the cultural requirement which is attached to religion, practice of religion. Now, my lord, in the Rajasthani families of the royals, they have the parda system even today. The daughter-in-law does not come in front of the father-in-law. Her face is covered by a gungat. The father-in-law has never seen the daughter-in-law. This I know as a fact in many, many royal families. And they still continue to practice it. That means they're wearing a gungat all the time. Now, is that a religious practice? Wearing a headscarf, is it a religious practice? Or is it a cultural requirement that some people thought it was necessary? And if we go back and forth, my lord, in the history of the religion, the religion of Islam, my lord, originated in Saudi Arabia. The conditions were harsh. The situation there was difficult. There were some essential religious features. For example, my lord, 5 times you have to pray. That's an essential feature of the religion. Now, my lord, we all know that in today's world, it is not possible for every Mohammedan to get up and stop whatever he or she is doing and go for prayer. Lord, among Hindus, my lord, just after Upanayanam, we are supposed to do Sandhya Vandana 3 times a day. Pratha Sandhya, Madhyanika, and Sayam. That means these 3 times we are supposed to do. Now, my lord, it is not physically possible. I am arguing a case before your lordships at 12 o'clock in the afternoon. I can't say excuse myself and that I'm going to go and do a prayer. And if the court says, no, I'm not going to allow you, can I turn around and say, you're curtailing my right to practice religion? Because my religion says that I must do 3 times. Same thing, not with the numbers. Now, praying 5 times a day is something which is prescribed in Islam for Mohammedans. We respect it, no difficulty whatsoever. But my lord, supposing I'm riding a scooter right in the middle of the road and there's a mosque which azan is called, do I stop the scooter there and start praying in the middle of the road? If I do it and the policeman comes and says, hey, why are you doing that in the middle of the road? You'll say, come on, you are preventing me from practicing my religion. My religion tells me I have to pray. Therefore, I'm going to pray in the middle of the road. No, that can't be permitted. That is not the answer. My respectful submission is this, my lord. I'll develop on this, my lord, tomorrow by another half an hour or so. The submission that I'm not making is that this practice of wearing a headscarf is really not an essential religious practice. I respectfully adopt, my lord, what the learned Advocate General argued, that there are some practices which are absolutely essential in religion. Now, my lord, I'll give one example, my lord. You have to do Antyakriya for your parents. When they die, my lord, there is a rite that we have to perform. That is a duty of the son to perform. If he doesn't perform it, there are consequences of it. The Shastras say that he will be punished by an appropriate punishment either in this life or in the next life. That means there's an injunction, there is a punishment. There's a positive direction and a negative connotation of it. Now the same thing, when you have your Upanayanam, you are supposed to do Gayatri Jap. That is a religious rite which you are required to do. Now if you don't do it, then there is a consequence of it. Now, my lord, what I'm suggesting is this cause and effect of it. only those which are absolutely imperative and essential, only those can be treated as an absolutely essential part of religion. So, my lord, if there is a regulation, now, my lord, we know of the case, I cite that also, my lord, the Azan case. Now, the Mohammedan religion, Islam religion, my lord, says you can pray. But the question is arisen, you can pray, but if you put a loudspeaker and you play the loudspeaker at a high volume at 5 in the morning, I'm living next to the mosque, and I say, look here, I don't want to be woken up every morning. I respect you. I respect your religion. I have no problem if you're practicing your religion. But in the course of practicing your religion, if you are interdicting or coming in the way of other people's peace and joy, then where does the line lie? That is not exactly what has happened in this case. Not, if I may go to, my lord, the annexures to the writ petition, if your lordship sees the guideline, my lord, I think it's 445.
Yes, sir. Continue. We'll extend. You finish your argument. We'll continue your hearing you. Today itself. Yes.
I may not be able to finish, my lord, because I have some authorities to cite, which I'll place it. I'll not take more than 15-20 minutes tomorrow if your lordships give me, my lord.
All right. Then we'll call it a day.
Whenever your lordship gives me, I don't take more than 15 minutes or so.
All right, then tomorrow.
Please, ma'am.
And your lordships may permit me, my lords, to make my submissions after Senior Mr. Naganand has finished.
All right.
Lords, I'll need a little time for rejoinder, my lord, to the AG submissions. Just a little.
You will get your time.
Yes.
I'm the last, my lord. I'm also in the fray, my lord. Grateful.
The London Advocate General, appearing for respondent, has concluded his argument. Mr. R. Venkataramani, the Senior Advocate, appearing for respondent number 12 and 13, has also made his submissions. Mr. S. Naganand, Senior Advocate, appearing for respondent number 5 to 7, is making his submissions. Put up tomorrow at 2:30.
Kindly, the submission of the government may be recorded in the serial number 1.7. So that
we will record it when your case will come.
Unaided,
You can dispose of if you regarding this statement, the matter can be disposed of.
The submission will be recorded in the.
Yes. All right, call out that case. We'll dispose of that matter.
1.7.
Call out that. Give the file.
Sir, I relied only on section 141 of the Karnataka Education Act, where the minorities are all excluded. So that's this notification I questioned. So now they are saying that.
Lords, in this, kindly see the prayer.
Yes.
Kindly see the prayer.
No, I confirm to that only.
No, I understand. No problem.
The ground is aided and unaided, but prayer is unaided.
Cannot
Page
be
7.
enforced on educational institutions of unaided, but we accede to that.
Then the grounds, both I mentioned it.
Main place.
Of unaided, including.
Yes, sir. Yes, sir. Because in the ground I mentioned about aided and unaided, so but anyway, the prayer it is to that. So this can be in terms of that the ground number.
Heard Mr. B.R. Mohan, Senior the counsel for the petitioner, as well as the Advocate General appearing for the respondent. The writ petition has been filed seeking following relief. The Advocate General appearing for respondent has made a statement before the bar that the government is not interfering in any manner in the minority unaided institutions.
Yes.
In view of above, where we considered view that nothing is required to be adjudicated in the matter, the writ petition is accordingly disposed of.
two petitions today filed for the clarification of the interim order, Lordship, which is the interim arrangement. If some clarification be given that also petition will be disposed of, Lordship.
What?
Because one petition is filed by the degree college students. College is the degree college is enforcing this particular interim order, citing this interim order on the college also, Lordship, which is not there in the preview of uniform and under in the Education Act. Another is a private PU college, Lordship.
We'll take up tomorrow.
Obliged.
All these fresh matters will be taken up tomorrow.
Okay, for record purpose, I will pass on these two judgments also, so that it will be helpful for the other matters.
All right, all right.
From the education and the.
Give it to the
Yes,
court
sir.
officer.
Unless you want to take.
Thank you.